If you're drowning in debt and thinking about bankruptcy, stop. There's a lot of misinformation about bankruptcy and how it actually works. Does it erase all your debt? Will it ruin your credit forever? Today, I'm going to be breaking down the truth about bankruptcy and debt discharge so that you can make the right decision. Once again, I've studied the legal side of debt, credit, and financial freedom, and today I'm going to be exposing what they don't tell you about bankruptcy. Now, once again, thank you guys for watching this video. It's a blessing to be able to be continuous and consistent and teach you guys this game. All right. A lot of people don't know and understand that there's pros and cons to bankruptcy. It's not a get out of debt free card, and we're about to talk about that. So make sure you like, comment, and subscribe. Make sure you stick around to the end of this video because I'm going to be giving you guys some tips and tricks so that you guys don't feel like that is your only option. Okay. Now, another thing I want to highlight, debt is a mental slavery. Okay. So if you feel overwhelmed, all right, if you feel like, you are in a position to where you have no other choice, think again. And hopefully this video can open your mind and open your eyes to the different options out there. Okay. Now, it was brought to my attention. I was talking with one of my clients and, he mentioned that, he had no choice but to, he wanted to go bankrupt. Now, obviously, if you have a strategy to go bankrupt or if you have no choice, I get it. Okay. But he had a lot of options. He had a lot of choices. Okay. And, some people feel like, because the emotions that they can't, they have no other choice. But that is the point. They want you to think that you have no choice. Okay. So let's talk about bankruptcy and how it works. Okay. So bankruptcy is a legal process that helps individuals or businesses eliminate or restructure debt. Okay. It's key word, eliminate or restructure. All right. Now, there's a Chapter 7 bankruptcy, which is more on the liquidation side, which wipes out most unsecured debt. Okay. What is unsecured debt? Unsecured debt is typically like credit card debt, anything that's not attached to an asset. Okay. And then there's a Chapter 13 bankruptcy that is geared towards more of a repayment plan. And essentially this reorganizes debt over 3 to 5 years. Okay. Now, here's a key point. Bankruptcy is not a get out of debt free card. Okay. It's not going to wipe away all your problems just because you decided to go bankrupt. Okay. There are some rules and some consequences if you decide to do that. All right. Stick around. Now, let's talk about the debts that can and can't be discharged based on a bankruptcy. Number one, the debts that can be discharged in the bankruptcy is credit card debt, medical bills, personal loans, past due utility bills, some, and then deficiency balances on repossessed vehicles. Now, we're about to talk about this, but this is stuff that can be overcame. You feel me? Now, here are some debts that can't be discharged. Student loans, unless you can prove an undue hardship. Child support and alimony. Recent tax debts. Court fines. Penalties. Criminal restitution. And most secured debts. So unless you surrender your property, like if it's a house or a vehicle, when you go bankrupt, unless you're giving those things up, you still got to pay it. Okay. So again, not all debt disappears just because you go bankrupt. Okay. In some cases, people may feel like you got a clean slate, but really think about the debts that you have and determine, is this something worth putting my credit behind, for these debts? You also got to think about how much debt you're in. Okay. And what is, what's the real reason why you think bankruptcy is the best option? Let's move forward. Now, here's the truth about credit after bankruptcy. The myth is that bankruptcy ruins your credit forever. Now, while bankruptcy can stay on your credit report for up to 7 to 10 years, you can rebuild your credit within 1 to 2 years. Okay? You can also get approved for credit cards, car loans, and even mortgages much sooner than you think. But there's still the aspect of you having a bankruptcy on your credit report. Now, you can remove a bankruptcy off your credit report using credit repair, because the U.S. courts say that you cannot put a bankruptcy on your credit report. You can remove that, but it will still show up in your public records, and there's some banks that look at your public records. Okay? So essentially, if you want to rebuild with the bankruptcy, for all my bankruptcy people who already have gone through this, then essentially you can get like secured credit cards and small investment loans. Okay. Now, I want to talk about some of the things that you can do prior to going bankrupt. A lot of times we think that you have no other option just because you have debt. And if you watch this channel, or if you have the complete debt guide, if you have been tapped into anything that we've been talking about, debt is not real. Debt can be challenged. And essentially the other side will have to prove that there is actually a valid debt, a verifiable debt. Okay? And also at the same time, you can settle. You can also negotiate your debt through conditional acceptance. Because when you look at House Joint Resolution 192, it says that, and even when you look at 31 USC 5118, it says that all debts are of the obligation of the United States. It says that in House Joint Resolution 192 that, what does it say? Pull this down. That since 1933, Congress enacted House Joint Resolution 192 to suspend the gold standard and abrogate the gold clause. Essentially, because of the existing emergency, okay, as disclosed that the provisions of the obligation which purport to give the obligee a right to require payment in any type of gold or particular kind of coin or currency are inconsistent with the policy of Congress in the repayment of debts. It also talks about how this resolution declared that any obligation requiring payment in gold or a particular kind of coin or currency, or in any amount in money policy, and every obligation herefore and hereafter occurred shall be discharged upon payment dollar for dollar, and any coin or currency which at the time of payment is legal tender for public and private debts. Now I talk about these things, and you guys can go and take a look at some of this case law. You guys can go check out my other videos. It also breaks down the fact that this substance was replaced with a public national credit, a system where debt is money. So if you have debt, debt is actually money. Okay? And the Federal Reserve even calls it monetized debt. Okay? So this is since 1933, and there's so much gems and so much information. I'm blocking it. Didn't realize I blocked it. See? It's so much information in here. This substance replaced with a public national credit system where debt is money. Federal Reserve calls it monetized debt. Okay? So if you guys don't know what the Federal Reserve is explained in Modern Money Mechanics. And essentially it's also explained in the Federal Reserve Act. Okay? So again, the Federal Reserve Act pretty much explains how the fractional banking system works, where banks actually, how banks create money. It also exposes that banks don't actually loan money. So just use your head. All right? Use your head. Damn. Why is it so... Okay. Boom. Now, moving on. Essentially, debt validation. Okay? You guys can literally, in debt validation, which is 15 U.S.C. 1692G. Actually, as a matter of fact, let me adjust it. 15 U.S.C. 1692G, validation of debts. Essentially, this is the very law that allows you to validate debt. Okay? And essentially, when you send a debt validation letter, there's a collection of information and documentary evidence in written form that they must provide in order to prove that the debt is valid. Okay? So some of these things are in this subsection. It talks about what they should send 5 days before the initial communication. So they should be telling you that you have a right to dispute the debt, how much the amount is, the name of the creditor, things of that nature prior to them sending their collection letter. Okay? Prior to them going through their process, they should be sending this to you within 5 days. Okay? Now, this isn't just a validation debt. The things that should be included when you're asking them to prove whether a debt is valid is, number one, they have to make sure that the amount of debt is correct. Okay? They must provide the original balance, any fees and interest and penalties added, and a detailed payment history. Okay? They also cannot inflate or misrepresent the balance. Okay? If they cannot prove how they calculated the debt, you can challenge its validity. Number two, if you are the actual person that owes the debt, so they must have documentation showing you are legally responsible for the debt, such as a signed contract, a credit agreement, or a loan application. Proof that debt belongs to you and not someone else. There's plenty of identity mix-ups. If they cannot prove this, you may not be responsible for it. And number three, debt collectors have a legal right to collect. Okay? They must provide a chain of title. Okay? Ownership proof. If the debt was sold, the collector must prove they legally own it. Number two, a bill of sale or assignment from the original creditor. And number three, each transfer must be documented if the debt was sold multiple times. So they must provide all of this documentation. And if they don't, then they cannot prove that they own the debt or they can legally collect on it. Number four, the name and address of the original creditor. If the debt was transferred or sold, the collector must provide the original creditor's name, the original creditor's address, and the account number tied to the debt. If they cannot identify the original creditor, they may be collecting a fake or outdated debt. Okay? You should also be able to get this notice above. Okay? If you didn't get this notice, they need to provide that they actually sent that notice. Okay? Now, when you actually send a debt validation letter, they must cease collection. Okay? So no calls, no letters, no lawsuits, and no reporting to the credit bureaus while the debt is verified. Because if they continue to collect without validation, you can sue them for the FDCPA violation. So for those of you guys that once you challenge a debt collector, they have to go through all this rigmarole before they actually can collect on a debt again. Even if they are taking money from you now, they have to stop. Okay? If the debt collector cannot prove these things, they must stop collecting the debt. They cannot report it to the credit bureaus, and they cannot sue you for the debt. And you can actually sue them for FDCPA violations and potentially get up to $1,000 per violation. Okay? Now, you may ask, what if they are able to show me this because they've sent me this, that, and the third? Then there's a couple things you can do. You can challenge the legality of the debt, okay, based off the Truth in Lending Act, based off the Federal Reserve Modern Money Mechanics, and demand proof of their original funding source, whether or not it was a real loan or simply just an accounting entry, okay? And if they don't respond to that, then you essentially send a debt validation follow-up letter demanding proof of the actual consideration and evidence that real money was transferred. If they cannot prove this, you can argue the debt is invalid or based on fraudulent lending practices. You dig me? You also can demand the original promissory note. If this was a loan or a credit agreement, the lender must have your original signed promissory note. Okay? Under UCC, a true creditor should have possession of the original wet ink signature. This is super important, so you ask for the certified copy of the original note. And if they do not have it, they may have sold or securitized the loan, and you can challenge their standing to collect. Okay, now remember, the promissory note actually is what monetizes the credit. You dig me? And then we can also go to the fact of once you start to challenge them based on the Fair Debt Collection Practices Act, and they're still doing things like reporting it to your credit report under the Fair Credit Reporting Act, which protects your information. They are also violating the Fair Credit Reporting Act. They're also violating the FDCPA by continuing to report. So once a company has violations, they are in the wrong. They cannot collect if they're violating your rights. You have to do your part first before you try to collect. And then you can also check the statutes of limitations in your state. Okay? There's places like New York, 3 years. There's places like there's I would just check. But there's some places it's 3 years, some places 10 years, some places it's 2 years, some places it's 6 or 7 years. Okay? But essentially, once you stop paying it, that's when you do your count. It resets after you agree to pay or when you pay. So again, if the debt is too old to collect, they cannot collect. All right? Now, you can also challenge the holder in due course, okay? Whether or not this is a legal enforceable debt, okay? Can they actually, do they have a right to, do they have a right to actually come after you for the debt? Is this debt even legally enforceable? Because if a lender sold your debt, they might not be able to enforce it. If your lender has settled the debt through a 1099 and charged it off, if the lender repossessed your vehicle, then sold it, made money off of it, and you didn't get anything out of it, you're not the holder in due course anymore, okay? So why are you still coming after me for the money if you already got your money? You just trying to be predatory. And UCC 3-305 essentially defends you against that. And then lastly, if none of this stuff works, be all right with settling, okay? You can settle and potentially pay 30 to 40% on the actual amount. Now, if it's an absurd amount, I get it. If it's not an amount that you'll be able to pay, I get it. You can also create payment plans. But as long as you start, if you do these steps first, challenge the debt, challenge the loan, challenge, the statutes of limitation, challenge whether or not they are properly assigned the debt, challenge whether or not they should be giving you, whether the money was already given to them, whether they actually gave you any real money or loaned you anything. When you get to that point, after you have done all of this, they're going to say, well, all right, this person's definitely, you know what I mean? This person's not playing around. So we'll take whatever we can get because we bought this already for $500 or pennies pennies or 10 cents on the dollar. We bought this. So if they make any type of profit, the profit for $30,000 debt, they could have paid, I'm just throwing this out there, they could have paid $3K for it. Boom, guess what? I throw y'all $3K, $4K. Now y'all make $1,000 and we can do a payment plan. You feel me? Y'all should be happy to get any type of money on a debt that y'all bought. And you and I don't even have an original contract. This is very effective against debt collectors. Okay? Now, if you do all of this and you realize that your debt is high and the settlement is unrealistic, you have lawsuits, wage garnishments, and aggressive collectors, or you just feel like you need a fresh financial start, bankruptcy may be your option. I'm not against bankruptcy if you have tried every single thing, okay? Now, you should avoid bankruptcy if your debt is mostly non-dischargeable, okay? So if it's student loans, taxes, child support, it's no getting around that, okay? You have a lot of assets you don't want to lose. So if you have a house, car, things in that nature, and you think that going bankruptcy is going to keep them from taking those things, guess what? They're going to take them. Or you're going to have to pay them regardless. Number 3, if you can negotiate instead of filing, if you can do everything I just discussed, if you haven't done those things, don't do it, okay? Bankruptcy should be your last resort, not your first option. Just because, oh, I just don't want to deal with it. No, it gets harder after you go bankrupt. Okay? That's going to stay on your record for a long time. And banks are still going to look at as someone who wasn't financially responsible. And they take advantage of those who actually went bankrupt, regardless if it's on your credit report or not. They still take advantage because they know you didn't know that you could negotiate your debt. You didn't come to BizNick's YouTube channel and learn the fact that you can challenge debt. They bank off of you not knowing this stuff. Okay, because now you guys know the real truth about bankruptcy, okay, and debt discharge, and that you can essentially, there's so many different methods out there that your only resort shouldn't be going bankrupt just because you're $30,000 or $40,000 in debt. Is it credit card debt? Well, try to negotiate that credit card debt. Allow them to charge it off, and if they charge it off, challenge them on whether or not it was supposed to be charged off. I mean, challenge them and get the 1099-C. Say, hey, the debt was settled, so why are you guys still trying to take money from me? When we look at all the things that they'll actually discharge, these are things that can be discharged by you without a bankruptcy. When it comes to unsecured debt, they get multiple times that money that they actually acquired through Federal Reserve and fractional banking. So, get out. And then there's some people that say, well, guess what? I just don't want to learn all this. It's too much to learn. You deserve it. If you don't want to learn, you really deserve it. You deserve to go through whatever you're going through if you don't want to learn. If someone is literally teaching you better or showing you better and you still decide, I'm just not going to do it because I don't want to, well, think about everything else you'll go through in life. Think about it. Okay? I don't want to do certain things or learn certain things, but I have to do it. If it was for your child, you've done a lot of things you didn't want to do for your child, for your family member, for your mother, for your father. Do it for yourself. And if it's not for you, then do it so that you can be able to help and teach other people. How dare you say, oh, because I don't want to do it or I don't feel like I can. Do you think life gives a damn? You think when you go bankruptcy, when you go bankrupt, that stuff gets easier? No, it doesn't. You have to be even more strategic. Now, if it's a business and it's separate from your name, oh, by all means, use bankruptcy to your advantage. But if it's on your personal person, don't play with yourself. Don't play with yourself. All right. So thank you guys once again for watching this video. Hit that like button, subscribe. I'll drop financial game every single day. Consumer law game, consumer credit game, whatever the case may be. Continue to better yourself, continue to fight, continue to challenge, and exercise your rights. We do this and we learn this so that we can get ahead of the game. Okay? So, if you ever thought about filing for bankruptcy, what's stopping you? Okay? Drop a comment below. I want to hear you guys' story. Maybe be able to come up with another video, be able to answer some questions. But either way, it's vice versa. What's stopping you from learning consumer law? What's stopping you from reading? What's stopping you from getting a complete debt guide that's only $47? That's a fraction of what bankruptcy would do for you. Oh, because I don't have time to learn, but you got time to be bankrupt for 7 to 10 years. What if I told you that if you did 1 hour a day in the next 3 to 6 months, all of this stuff will literally be broken down. You'll fully understand all of this. What if I told you that if you went through all of my videos and continue to stay up to date and watch every single video, subscribe to the channel, you wouldn't feel the need to go bankrupt? What if I told you that there was a program called Solo Suit down in the description where you just pay a fee and they'll actually do the negotiation for you? What if I told you that there are programs and things like that out there? You just gotta be willing to put in the work. Use your head, you guys. I love you guys, and I'll see you next time. Ha!